This is a very common question you find a lot of non-lawyers asking lawyers. And the question is, would you defend someone who you know is guilty of a particular crime, or who told you that he has committed a crime he's charged of? I will answer that question, whether it is right or wrong for lawyers to do so. All of that in this video. And as always, I am Godwin Selassie Dakbo, and this is Make It Legal. Make it legal. I want to believe you've also asked that question before. You are not alone. In fact, I equally asked myself that question many times before I became a lawyer. And sometimes what you do not understand can be a little confusing for you or for all of us. That is how it is. So if you don't understand what it means for a lawyer to defend or represent a client in court, chances are that you will draw a conclusion that this person that I have seen committed a crime or committing the crime in my presence, a lawyer has the moral right to take fees from that person and says that he's going to defend him in court. Or a lawyer is speaking in favor of such a person. No, let's condemn him at once. He has done it, he's done it. That is it. That is the matter. I mean, we live in a democratic state where it is a matter of rule of law rather than rule of men. So when you see a fellow committing a crime, or you allege that he's the one who has committed a crime, the rules of democratic dispensation require that that fellow is taken through a judicial proceeding, which we call prosecution or criminal investigation and prosecution. So he's not to be conclusively pronounced guilty just on the spot because you, Kofi Mensah, saw him committing the crime. Or you, Kofi Mensah, and one other person actually saw him taking the item, so he was the one who stole it. Democratic dispensation requires that we do not draw conclusion just by an observation of a fact. Because if we do so, chances are that people can get others framed up just to ensure they go to prison for not actually doing what they have been accused of. So this is what happens in practice. If you get arrested for committing a crime or for allegedly involving in an activity which is criminal in nature, the police are mandated to detain you for a maximum of 48 hours. Within the 48 hours, you are expected to be arraigned before a court. And that court would take what we call your plea. In other words, they'll read the charges to you. They will say, maybe count 1. Kofi Mensah, age 38, of this place, that on this date, on that date, you and one other person agreed together to go and do ABCD. Guilty or not guilty? They will ask you that question. That is, they are taking your plea. Okay, what is your plea? That is what it means. So they read a charge to you, count by count. Some of them, there'll be many counts. We count 1, 2, 3, 4, up to 20. Count 1 to up to 5. So they read each count for you one by one. And as they read it, they will expect you to respond to them by answering the question, are you guilty or not guilty? And you have 3 things to say when they ask you that question. The first thing is, yes, my Lord, I am guilty. And once you say that, it ends the matter. It means that if the law says that a person who commits this offense shall go to prison for 10 years, once you say you are guilty, the judge is duty bound to sentence you to prison for the 10 years. Or he can adjourn the case to another date and give you the sentence that is prescribed by the law. And that ends the whole case. And mind you, even at that stage, you will still have a lawyer with you, but I'll tell you why the lawyer is still there. The second thing you will say is that, my Lord, I am not guilty. And when you say you are not guilty, the judge is also duty bound to require of the prosecution, that is the state, who have brought you to court, to now go through the entire proceedings or processes to bring their evidence and witnesses on board to prove that you have committed a crime they have charged you for, or that you are guilty as they are asserting. So they are supposed to prove by evidence that you are guilty. Beyond all all reasonable doubt. In other words, they have to bring evidence to prove such that when we put all the evidence together, we cannot even remove 1% and say that you're not guilty. If we see 1% chance of you not being guilty, then you are not guilty at all. So the police must prove beyond all doubt. There shouldn't be any doubt at all that you are guilty. So that is their duty. So they will prove you guilty if you say you are not guilty. Now, if you say that you are guilty but with explanation, that is a third thing you can actually say. And when you say that, the judge is expected to write it down, that you say you are guilty with explanation. And the judge will take your explanation. What is it that you have to say when you say you are guilty with explanation? You say it, and the judge must record it down. Now, when the judge forms opinion that what you have said actually meant that you are guilty, the judge is entitled to consider your plea of guilty with explanation to be guilty. And when the explanation shows that you have actually not done it, maybe you didn't understand what it meant when you say you are guilty. So what you actually said by way of explanation shows that you have some defense. And the judge will say that, okay, from the explanation, I think you have some defense that you may likely bring on board, which can affect the charges they have brought against you. In that case, your guilty with explanation would be considered as not guilty, and the state will be invited to take you through the process to prove you guilty beyond all reasonable doubt. That is the procedure. The truth is that before you get to this stage and take the plea, there are a lot of criminal investigations ongoing already. There are a lot of legal proceedings being undertaken already, all in respect of you because you've been alleged. And in all those stages, the law requires that you as a person can say that you will represent yourself in interacting with the state institutions and the court in all matters pertaining to the alleged crime, or you will be represented by a lawyer. And the option to choose a lawyer to represent you is a constitutional right you have as a person who has been accused of committing a crime. It is your constitutional right, a right given to you by the Constitution, that you prefers that Godwin Selassie Dapo represent you in all legal proceedings. Number one, when you were arrested by the police and they are about to take your statement, once they say, accused person, Kofi Mensah, hey, come here, we want to take your statement. We'll ask you, you have a right to a lawyer. If you choose to represent yourself, you can do so, blah, blah. I mean, you have the right to say that I want a lawyer to be present before I give my statement. And that is your right. So you can say the lawyer should come, because you know that you've done the thing. You know that you have done what they have alleged that you've done. But you are still required to ensure that a lawyer is present with you before you give your statement. Why is it important to have a lawyer with you even when you think you've done what they are alleging that you have done? 4 reasons, and I will explain that to you. And by explaining them, I want to say that whether or not you know you've done what they have alleged that you've done, you still need a lawyer to represent you, or as you may call it, to defend you in the proceedings, because there's a lot more beyond just the assertion or the assumption or the conclusion that you've done it. Let me take you through 4 reasons why I think whether you have declared yourself guilty or not, you still need a lawyer to defend you or to represent you. I share those reasons with you now. The first one is that you need a lawyer to explain to you the consequence of what you are saying in court or before a police officer. So when you are arrested and kept at the police custody, the police would give you the opportunity to write your statement. Before you write it, you need to understand the implication of what you are writing. What is the statement when given to a police officer during investigation? What is the legal implication of that? Does it affect me in any way? Can I say I will not write it? Can the police beat me and expect me to write it? Can the police dictate it to me and say I should write what they are saying? These are all legal issues. When you are not a lawyer, you may not understand. And a lawyer needs to be there to explain it to you. So you need a lawyer to explain to you the implications of everything that is happening throughout the legal process or the criminal investigation proceedings, a lawyer needs to explain them to you. Another thing you need to note is that when you say that you are guilty, what does it mean? Does it just mean, oh, I have done it? Yes, I did it. But what you think you have done and what the law say must be done before the law will say you are guilty. Are you sure that you know what the law say you must do before you be guilty, before you say you are guilty? Hope you understand what I'm saying actually. So there is always a set of elements, as we call it, a set of facts that must be present before a conclusion will be drawn that you are guilty of a crime. Those set of elements of facts are within the law, are created by the law. So if you don't know what the law says or which fact the law has outlined, how did you come by the conclusion that you are guilty? Oh, or was it because you were the one who threw the cutlass and it injured the person who died? And you think by that alone you have committed murder or manslaughter? Or you were the one who killed the person as the police alleged? Could there be more? The persons who know whether there is more or less are those persons who have been trained for several years in matters of law and in legal issues, matters of crime, matters of criminal investigation, and they are called lawyers. So you need them to be there to be sure that the right things are being done to you and you understand the implications of the things you are doing. So even though you know, yes, I was the one who engaged in an unlawful fight, you still will need a lawyer to be there with you to explain the proceedings to you one after the other. To tell you that when you say you are guilty, you mean that I have done it in accordance with the law. Therefore, I deserve the punishment the law says should be given to the person who does it. That is what it means when you say you are guilty. The lawyer needs to explain that to you. And when you say you are not guilty also, what does it mean? The lawyer will explain that to you also. And when you say you are guilty with explanation, what does it mean? And what explanations are justified and which ones are unreasonably unjustified? It is a lawyer's duty to explain all of that to you. And if it's not with you in the proceedings, he cannot do so. You will be disadvantaged if you don't have him with you. That is why even though you think you've done it, you will still need a lawyer to defend you, as we term it. Very important. The second reason why I think you need a lawyer with you, even though you think you are guilty, is that you need him to mitigate your sentence. Once you say you are guilty, the judge is supposed to, set a date to give you the sentence. Say, go to prison within this number of years. Most times, most offenses you will see in the law would have, say, if you commit this crime, you should be sentenced to 5 years, but not more than 25 years. You should be sentenced to prison terms between maybe 5 to 25, 5 to 27, 1 to 10 years, or 2 to 10 years. I mean, various offenses will have different kinds of sentencing regime or prison terms. If that is the case, it is important that the judge considers a lot of factors about what you have done, setting example to others, ensuring that you who is a young person doesn't get to be deprived of the opportunity to live your life and contribute to national development and all of that. The judge looks at a lot of factors before he or she comes to a conclusion that I'll give you 15 years out of the 5 to 20 the law prescribed. I'll give you 10 years. I'll give you 20. So when your lawyer is with you, he's able to explain to the judge why you should not be given the 25, why you should not be given 5, why you should not be given 10. The lawyer tries to do that, and he does that by mitigating the sentence, making argument, bringing facts across to the judge. Why maybe if the judge gives you 25 years in prison, it will affect you. And some of the reasons you hear lawyers argue will be that this particular accused person is a first-time offender. This is his first time he has ever committed a criminal offense. Therefore, my Lord, have mercy on him and don't give him all the full 25 years in prison. Maybe instead of asking him to go to prison, let him pay a fine for his crime. You're not saying that turn around the guilty to become not guilty, but you are pleading for mercy. You are pleading for reduced sentence. And that is why you need a lawyer to do it with you, to be with you and to do that for you, because that is what he's trained for. He'll put all the facts across. Maybe you are a young offender You are a person who is responsible in society. You have a kid who is just 1 year old, and your wife who delivered is still at home, is still a nursing mom. So send you to prison for 20 years or 10 years would affect the life of a child, a young child who needs to grow with their parents as a right, constitutionally guaranteed. So the judge would consider all of these factors, bring to his attention. Then if the judge is persuaded, the judge will go ahead and give you a reduced sentence. That is why, even though you think you are guilty, the lawyer must be there with you to guide you through the process. The third reason is that you need a lawyer to be there with you, even though you think you are guilty, because you are not familiar with the court system and the laws of Ghana. You are not familiar with it. The law presumes that you know the law, but you do not, in fact, have actual knowledge of all the laws. There are those guys who have gone to school and have been trained as experts in matters of law. They are called lawyers. They are the right persons to stand by you when you are going through the criminal proceedings or the court system. They have been going to court literally every day of their life. That is their job. Why go to court for the first time? You don't even know where you will sit. You sit at the wrong place. Look at this video.
Okay, let's go.
Why are you holding me now? What is wrong with you now?
What is wrong with you? Are you not the one they accused, boss?
Yeah, now you will accuse you.
You must be mad.
Now my first time. I don't know how the position of sorry, sir.
Say accused, they find accused. Ish, no excuse. You are the accused.
If I can even tell me, son, they see all this small.
He's gone. Yo, hey.
Let's go.
Hello, a minute.
50 years.
For the meantime, or wait.
Jesus!
Hello, sir.
That is my good friend Sabinus. He went to court for the first time, and as a lawyer, he went to enter the witness box, allowed to stay there, and he was pronounced guilty and all of that. You could imagine, it's quite funny, but that is actually the reality of many people. They get to the courtroom and don't know where they're supposed to sit. They don't have any idea where lawyers sit, where judges sit, and where people who are in the world of the court sit. So the people who understand the issues of law and the judicial system are lawyers, and they're supposed to guide you on where you should sit and what you should do, what you should say. When the judge calls the case, what do you do? If you want to talk to the judge, what do you say? Do you just shut up and say, "Madam, please, I'm sorry"? Do you say that? Do you call the judge "Madam" in court just because you want to be humble and respectful to the judge? Is "Madam" or "Mr." or "Sir" as an address to the judge proper? There are people who have been taught these things, and they are the ones who know what is right or wrong. That is why, even though you think you are guilty of the offense, you still need a lawyer to be with you. Have I convinced you so far that even though you think you are guilty, a lawyer must still stand by you? Well, if you're not yet convinced, wait for the last one. I believe that will convince you the more. But whilst you wait, please do us a favor, hit on the subscription button right now, just here. You see, subscribe. Yeah, do so. And when you are done, turn on the notification bell so you can receive every notification that comes from us and be updated of our contents. And please don't forget, as always, like our videos and share it. And we are super excited to read your comments in the comment section. So drop them, engage us, and let's engage you too in the comment section. Let's get talking. The last point is that the conclusion as to whether you are guilty or not guilty does not lie in any other person except yourself, the accused person, you who is accused of a crime, or the judge, before whom the case or the charge has been proved by evidence beyond reasonable doubt. Now let me say that again. The conclusion as whether you are guilty or you are not guilty does not lie with any other person except you or the judge, before whom it has been proved by evidence beyond reasonable doubt that you are guilty. In other words, the witnesses who saw you in flagrant delicto, who saw you fili with their own eyes committing the crime, do not have the power to pronounce you guilty. The policeman who comes onto the scene to arrest you, sees your body, take you all the way in their van to the station and lock you up, does not have the power to determine whether you are guilty or not guilty. The judge who sits down and hears your case does not have the power to determine that you are guilty unless it is sufficiently proved by evidence before him that you are guilty. So two things. You yourself have the power to determine that you are guilty, or the judge has the power, if it is proved before him that you are guilty. So if that is the case, it is important that you have the lawyer with you to ensure that the persons who have the power to declare your guilt exercise the power in accordance with the law. If for nothing at all, you need a lawyer to be with you for these reasons. I believe this reason is so important that you do not get to be in prison or lock up by the wrong persons just because it was the cry of town that you did it. Everybody in the neighborhood was pointing to you. I'll give you a very popular story you might have heard about. There was a crime scene. People were, involved in armed robbery, and the eyewitnesses around started shouting, "He's the one, he's the one, he's the one, he's the one," pointing fingers at people. That was where this gentleman was arrested. And because it was so sympathetic that he's the one, it looked so real, he himself was even affected. He was shivering and couldn't even defend himself. That is how he was picked by the police, sent to the police station, kept in custody for days, then subsequently arraigned before court. And guess what? Evidence was available somehow to show that he was the one who did it, because the eyewitnesses, in their estimation, in their perception, thought that he was the one who did it. And the judge also say, okay, if the eyewitnesses are saying that you are the one who did it and they have collaborated their evidence, this person is supporting this person, then I have no choice than to agree with them. In view of that, I'm going to sentence you to prison. The judge goes ahead and sentences the gentleman to prison. He spent 14 years in prison before evidence came up to suggest otherwise, that he was not the one who did it. Now, in a scenario like that, he has been wrongfully convicted, and the law requires that he is compensated by the state. But that oftentimes hardly happens. So imagine there's a lawyer with this person from the very onset, who guides him to the process, who tries to ensure that he points to the judge's attention that the eyewitnesses were wrong in their perception of who committed the act. They were wrong in how they observed the person who did the act. Because when they paid attention closely, they would have realized that my client was wearing the same white shirt as the person who did the act. Therefore, the fact that he was wearing white shirt does not mean that he was the one who did it. I mean, it's a possibility that you can be wearing the same shirt or the same color of a shirt with someone who committed a crime, and he will run away from the crime scene and he will be arrested. Because, I mean, the guy who did it is wearing red, he's wearing yellow, he's wearing red, he's wearing yellow. That's what everybody is saying. And everybody is saying the same thing. What it means is that there is evidence that the person who did it is wearing yellow, and they will come after you who is wearing yellow and was in the same area, but you were not the one who did it truthfully. But you need a lawyer to make a strong case for you to have your freedom. That is very important. And I believe I've convinced you as to why I think that you still need a lawyer to defend you or represent you in a criminal matter, even though you think you are guilty. As always, I am Godwin Selassie Dakbo, and this is Make It Legal. Make it legal.